morning and good afternoon to in-house counsel from all across North America. Welcome to In-House Connect. My name is Shai Mahani. I am the CEO and founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast or your lunchtime with us, and special thanks to our presenters and sponsors today, the fantastic Dave Stevens of the Stevens Law Group and McCoy Smith of LexPan Law, who are going to demystify the world of open source software for us today. For those of you who are here for the first time, let me give you a quick bit of background. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect organized free CLE classes, which were hosted by different law firms and which were then followed by cocktail networking receptions. Every 6 months, we would organize fun and festive networking mixers. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then, of course, COVID hit. We couldn't meet in person, so we went online, and it's been a fantastic transition. We've been able to attract a much larger audience of in-house counsel from coast to coast, been able to facilitate way more networking and relationship building, and we've been able to feature high-caliber speakers like the two we have today, who I'm going to introduce in just a few moments. This is our 22nd event of the year so far, and I'm wondering, are you here for the first time, or are you a frequent flyer? So let me know in this poll. I see we have 53% are first timers. So welcome to the 53% and the 9. Oh no, now it's 54. Welcome to the to the 46 and the 54 to the new and old. Welcome. I hope you enjoy it. So now for today's event, open source software for in-house counsel, best practices to adopt and pitfalls to avoid. Our presenters today are Dave Stevens and McCoy Smith. Dave Stevens' IP practice includes patent prosecution, transactions, due diligence work, agreements, opinions, including validity and infringement, patentability, right to practice, and freedom to operate opinions, counseling, offensive and defensive patent issues, licensing, and litigation. He also serves as an expert witness in the technical and intellectual property legal issues, and has been called as a fact witness in enforcement actions involving the many patents he has written. He is also an expert in copyright, including software publications, products and artworks, and other copyrightable forms and open source issues. He works with foreign IP firms and foreign clients with respect to domestic and international patent prosecution, including patent cooperation treaty work. Our next panelist is McCoy Smith. He is the founding attorney at LexPan Law, a full-service technology and intellectual property law firm based in Portland, Oregon, and Obsequio, an open source compliance consultancy. Prior to his current position, he spent 20 years in the legal department of a Fortune 50 multinational company as a business unit intellectual property specialist. And among his duties was setting up the free and open source legal function and policies for that company. He preceded his in-house experience with 8 years in private practice in a large New York City-based boutique intellectual property law firm, working simultaneously as a U.S. patent litigator and a U.S. patent prosecutor. He was also a patent examiner at the U.S. PTO office prior to attending law school, and he is licensed to practice law in Oregon, California, and New York, and to prosecute patent applications in the U.S. PTO office. And he's also a registered trademark and patent agent with the Canadian Intellectual Property Office. So we are so lucky to have Dave and McCoy with us today to teach us best practices with respect to the tricky world of open source software. And with that, I'll turn things over to Dave and McCoy to get us started.
Yeah, thank you so much for that. And I'm really thrilled to have McCoy Smith here with me. If there's one thing I can emphasize, one thing you can walk away with here is that when you're dealing with open source, you need to work with people and have advisors who have a real deep experience in this, many years, because these things have evolved over the years. There's so many licenses and so many details. I wouldn't call it a black art, but it's really a system for the informed. So we're going to try to inform you as much as we can today, give you some basics, and give you an idea of at least issues to spot and what to look out for when you're dealing with open source, and maybe when you're doing a triage internally to see how your company is using open source. So those who have seen my other webinars, you've seen this visual, and it's as relevant here as anywhere else. The goal is to be a sophisticated consumer of IP services and really understanding how your company deals with IP. And today we're going to talk about understanding open source. And as you see from these visuals, intellectual property comes and goes through the walls of your company. And there's nothing more relevant than open source, because it's the one thing that simultaneously can cause your IP to come inside your company, from the outside and your IP to go outside the company. And it's something to be very sensitive, and you want to be really aware of it. So overview, here's the first poll question. Does your company currently make use of open source software? And there's 4 different options. Yes, both internally and in products we deliver to customers. Yes, but only internally. No, definitely not. I'm not even sure what open source software is. That's why I'm taking the CLE.
Dave, let me know if you have any issues seeing the poll or.
Looks good.
It auto popped up.
Right. So good. So there's a mixture of all of them, right? And at least there's most of the audience here is aware of that they're actually using open source. So here's some open source realities, right? It's everywhere and readily accessible, and many software engineers are using it. You know, your software engineers are likely already using it, whether they know it or not. It's better to get ahead of your own use than to be left or set behind. And it's good to be aware of what you are responsible for in using these open source. In a bit of the history, you know, the early 1990s, you know, it was kind of an unknown, and a lot of this open sharing, and there was a lot of fear and of using it and what effect it would have in your company. From the mid 2000s to 2010s, there was some caution, but today everybody uses it. It's embraced. And as long as you understand your obligations and really the benefits that you're getting, you can make these business decisions of how you're going to use open source software. And I say how because you're likely not going to not use it. You're more likely going to use it because it's a very valuable resource to the company. Poll question 2. When I think of an open source software, my general feeling is it's a useful tool for companies to leverage existing tested code without having to recreate the wheel. It has pluses and minuses depending on the software and the license. It can help or hurt. It's a pain in the neck to administer license compliance and generally not worth the trouble. It's a massive backdoor to our IP portfolio and a liability nightmare. Open source basics, differing open source models. McCoy, if you could take over from here.
Yeah, so I'm going to go through a little bit about how kind of what these open source licenses are about and in general the categories. The nomenclature that's used in this field varies. Open source, I think, is the most typical, but you also hear this stuff referred to as free software. These licensing models encompass many, many hundreds of different licenses. Just a couple of resources to be aware of. There's a thing called the Open Source Initiative, which is a nonprofit entity that administers a thing called the open source definition. And they actually will review licenses and include them on a list of licenses that they say satisfy this thing called the open source definition, and which otherwise they feel are legally valid and robust. This is sort of the canonical place where one goes to determine whether somebody is delivering to you an open source license and what the terms of it are. I've included the link here, so in case you ever want to go to that site and learn about it, it's right there. There's about 100 licenses on there, but if we go to the next slide, there are actually many, many more than those licenses that are within the open source ecosystem in which people are using. There is an organization called Software Package Data Exchange, which is a mechanism that's intended to be used to deliver a human and machine readable information about the license that is attached to a particular piece of software. They have, the last time I counted, over 260 different identified licenses that people have associated with their software or other content as open source. Now, not all of these may be open source according to the open source definition, but if you're ever trying to find information about a particular license, this is another place that you may want to go to reference, as well as to learn about SPDX in general, because it's a very useful tool when you're using things like code scanners that are used to identify open source within your software stack. in a nutshell, open source, there's two really important characteristics you need to be aware of with open source. One is the recipient of a piece of software under an open source license is entitled to get the source code for that software if they get a copy of the binaries or the executables. And for those of you who are not familiar all that much with software and how it works, binaries or executables is essentially the machine readable version of software. So that's what the computer loads and executes when it is running a piece of software. The source code is the form of that software that the programmers use in order to understand how the software works and to make modifications to it. So there's two different forms. One is for the computer, one is for the human. And your open source licenses are designed to give to the human a version of the software that they can read, modify, etc. The other important characteristic is these licenses say you can't impose restrictions upon what the recipient of the software can do with the code, either the executables or the source code. Now, that's important because without restrictions, that means they can do whatever they want, including potentially taking the software and making something that is competitive to what your company may be doing. Now, a word of caution here, I use the term restriction here. Generally, you're not allowed to restrict how the software may be used or modified, although all of these licenses impose certain obligations upon you, which we'll talk about a little bit later, which are generally not considered to be restrictions, but in some people's mind, they may be a restriction in terms of the way that you may be able to use the software. Okay, let's go to the next one. As I said before, there are two different nomenclatures that are used here. One is open source and one is free. The open source nomenclature is promulgated by this organization called the Open Source Initiative. The free software nomenclature is promulgated by a different entity called the Free Software Foundation. These two nomenclatures mean essentially the same thing, although there are some important philosophical differences between the two, which, if you get deep into this stuff, are important and you should be aware of. But for the purposes of this discussion, I think it's probably worth just saying it. These essentially are the same things. If you see somebody using the term free software or open source software, they generally mean the same thing in terms of what you need to know about the software and the license that comes with it. Okay, so Shai's going to pop up another poll question here. So in terms of my understanding of how open source licenses work, A, I'm very comfortable with what I know. B, I understand some of the basics, but not a lot of the details. C, I don't really know that much. And D, I'm not sure I want to know. Okay, so it looks like most of you feel like you know the basics, but maybe not a lot of the details. And then some are very comfortable, maybe a little bit more, really don't know all that much.
Definitely the right place. Yep.
Let me read off the results because some people can.
Okay.
15%, 14% say I'm comfortable. 47% say I understand some of the basics, but not all of the details. 34% say I really don't know all that much. And then 4% say I'm not so sure I want to know.
Mm-hmm. Well, the good news is for everybody here, in-house counsel, general counsel, assistant general counsel, whatever your position is, you can become an expert to the extent that you need to be an expert. And you have experts on, in your lifeline, like McCoy and I, who can help you through the troubled areas and help you set up your program and understand it as much as you need to. And you'll be the internal expert.
Okay, let's go to the next one. So this graphic is a representation of what I like to think of as the open source continuum. So there are three general categories of types of open source license that are often used to differentiate between different forms of open source license. And you will see this nomenclature used quite a bit within communities who talk a lot about open source and open source licenses. And the three categories are what's called strong copyleft, weak copyleft, and either permissive or academic, or sometimes it's called non-copyleft. And I've used this arrow here and the coloring of the arrow as a representation of kind of what they mean for you as an in-house person. The strong copyleft licenses are ones which are going to have more stringent obligations that you need to be aware of and need to understand in order to follow. The weak copyleft licenses are sort of in the middle in terms of the obligations that you're going to have to follow. And the permissive or academic or non-copyleft licenses are the ones that have a fairly limited number of obligations on you. So they impose a little bit less of a headache potentially for you if you have licenses like that you have to deal with. So let's go to the next slide. I'm going to go through each of these in sequence so you can understand a bit about them. So strong copyleft are the ones that have the most obligations that you need to be aware of, and the ones that may cause more issues for you to ensure that you're compliant with them. And the main characteristics of strong copyleft licenses is that they say copyright derivatives that are made of the software that you received must be open source as well. And for those of you who have studied copyright law or remember it from law school, what is or is not a derivative under copyright law is not exactly a clear question. One which is oftentimes a very fact-dependent analysis. So it can get somewhat complicated when you're dealing with these licenses to understand when these obligations are going to attach to you, when it is that you may have created a derivative work, and therefore you may have to be aware that you're having to follow the obligations of these licenses. Another thing to be aware of is kind of the triggering effect of these licenses. Generally, the trigger for these licenses is if you are distributing licenses outside of your organization, your company, you are going to have to follow all the obligations of these licenses, which include providing source, etc. Now, not all of these licenses are triggered by distribution. There are some where if you are allowing people access through the internet to your software, you may have to comply with these obligations. But in general, most of these licenses, once you ship software out the door, you have to comply with the license terms. Okay, so those are the general characteristics of strong copyleft licenses. Weak copyleft licenses are a variation of strong copyleft, but the difference is that they will say that some derivative works that you make based on the software that you receive must be open source. And what's interesting about these licenses is which derivatives you're required to make open source really is dependent upon the license itself. So you have to familiarize yourself with what the license says. It says, if you do X, you must open source your code. If you do Y, you do not have to. You have to familiarize yourself with what these licenses exactly say with regard to your obligations to understand what obligations they impose upon you or whether you don't have to abide by those obligations. So the general gist of these licenses is they want to make it possible for you to create code that interacts with the open source code without forcing that interacting code to also have to be open source. But depending on the license itself, the form of interaction you do may or may not trigger these open source obligations. Okay, let's go to the next slide. So the permissive licenses are the ones that have the least number of obligations, and they're probably the easiest to deal with. So essentially a permissive license says, as long as you preserve certain copyright and other author identification requirements, And as long as you let people know the license that you originally got it under, you don't necessarily have to make your software open source if you use this software to create it. So those sorts of licenses tend to be much easier to deal with because all you're really doing is going through some ministerial obligations to preserve certain notices with the code that you distribute. Now, that doesn't mean you don't create a problem for yourself. There's a case called Jacobson v. Katzer. For those of you who are familiar with open source litigation, you may be familiar with it. Otherwise, it's one where somebody actually failed to abide by one of these permissive licenses and got sued. So you still have to be careful to abide by the license, but it's generally easier to abide by them. Now, in terms of the license categories and the licenses that fall within those, as I said, there are many hundreds of these licenses out there, and it would take me forever to describe each of those and where they fit into these categories. But what I have done here is to identify a handful of licenses that are frequently and commonly used, or ones that you will frequently see attached to open source licenses if you ever have people in your company who want to use some. And I have sort of categorized them within these three classes of licenses. So the GNU General Public License family of licenses has several different licenses that fall into the strong copyleft category. There are several other licenses, including the lesser GNU General Public License, the Eclipse license, and the Mozilla license that fall within weak copyleft. And then there are a variety of different permissive licenses out there. The most commonly encountered would be the Apache 2.0 license, the BSD license, of which there are several variants, and the MIT license. There are many others along this continuum, but those are kind of the big ones that you run into frequently. Okay, let's go to the next poll question. My biggest IP concern with open source software is A, I will have to give a free license to software for which I currently charge. B, I will be forced to disclose confidential source code for my software. C, I will license important patents to a competitor. Or D, I have no concerns. And I'm gonna let Shai recite out the results once the poll results come in.
Yeah. So we have about 70% reporting, 19% say the biggest concern is I will have to give a free license to software for which I currently charge license fees. 60%, whopping 60% say I will be forced to disclose confidential source code for important software technologies. 9% I will license important patents to a competitor, and 12% are totally cool with open source software and have no concerns. Back to you.
Right.
Okay, I think we're going to transition over to Dave now.
Yeah, that's really informative, by the way, those poll questions, and those are all very genuine concerns, and they're often found. But one thing we want to emphasize today is that, as I always say in these different webinars, is you need a holistic view of your intellectual property program in general, and open source in your intellectual property is part of that. And you're always going to be making, just really balanced decisions over, are you going to use open source? And it usually is very compelling, especially Apache, because, many programmers use those. Most of my clients use Apache, but they still file patents. So I'd like to dispel that one myth, is that just because you're using open source, you can still patent your technology. It's what you build on top of the open source that is yours, that's original, right? Patents, copyright, trademarks, and trade secrets, these are still all very viable intellectual property that you can protect. Some IP more than others, some licenses more than others are affected by using open source. But you need to view your use of open source holistically. And it doesn't necessarily mean that you're giving away the farm because you're using open source. You just need to be aware of the risks that you're taking, hopefully, dispelling those risks and just understanding what you're getting and making your business decision and moving forward. You protect what you can protect, your important, your strategic intellectual property, and you use open source to streamline your programming for your engineers. For patents, you can file for and obtain patents while using open source. And just be aware that with these licenses, and be aware of the licenses that you're using, what your obligations are. You may decide not to file patents because you're giving free licenses to them anyway, but the underlying obligations that others have that use your open source code, you can enforce your patents, copyrights, and trademarks on them when they don't comply with the license. That's the tool. These are the tools you use. It just doesn't mean that you give away this intellectual property, you stop protecting it. You want to make sure that you're protecting your intellectual property, that you're engaging with the open source community, and you understand what your obligations are and what are the obligations back to you if you submit code. So many open source licenses include express patent licenses. Just be aware of those, right? And they're under those same obligations. The others may have implied patent licenses. So again, you want to be really well informed of these licenses. And something like McCoy, who deals with these licenses every single day, can usually give you some pretty quick answers. And what can be important to your company, if you haven't done it before, is to do an open source audit. And that's probably a subject for another talk, but essentially it's getting the experts in there, doing a triage, talking to your engineers, not reading all your code. It's not that invasive, but understanding what your open source uses are inside your company. And then we can, look at the licenses. You can understand the licenses and understand what you've gotten yourself into and what you could be getting yourself into. And it can be extremely beneficial to move forward with these. You just need to understand what your obligations are so you don't have these liabilities, and then you can fully benefit from open source and understand, again, holistically, being aware of these licenses and protecting your IP accordingly. Copyright, same thing. Your copyrights, it's another tool to protect your intellectual property so that when you engage in open source, whether you're submitting code, using code, you have copyrights to enforce your rights when those under obligation are not fulfilling their obligations, who are not sharing their code, or they're not using your code properly. Maybe they're modifying the code improperly, making derivative works. Copyright. And if you don't have this intellectual property protected, if you don't have these, whether they're registered or you keep common law rights, you're not going to be able to stop the misuse of your code, and you're going to want to protect yourself. What you get with an open source license, it tells you what you can do and how you can redistribute the software. What you get with copyright ownership, all rights attendant to ownership, right? The right to sue for unlicensed uses. So it's controlling the obligations. You have to follow the code. If you use the US code, if you use the open source code, if you don't, you can be liable under the owner's copyright. So it works in both directions. Trademarks, the same thing. Trademarks are protected by their use. If you have an open source program and you trademark that program, you call it, your company's open source, and you engage in this, then you're going to have other people using your trademark. And you have to decide whether or not you want to control use of the trademark of your open source. But the trademark for your company is still yours. You don't give away your brand just because you're engaging with open source. You want to protect your brand, monitor your brand, regardless of whether you're in or out of open source. And there are no licenses that require you to give up your brand just because you're using open source, right? If you grant a trademark license for use for the products of others, you need quality control. So keep that in mind, right? So you wouldn't grant a trademark because someone else is using your open source necessarily. But if you are granting a trademark under these or any other circumstances, you need to protect your trademark by quality controlling the use of those products. But that's typically not what you get into in open source. Trade secrets, they're protected by your trade secret procedures, right? Trade secrets are, they don't really play much in open source because what you're disclosing, you're giving it up to the public. That's pretty much your obligation, right? If you are concerned about trade secrets, algorithms, and things, you want to strongly consider whether or not you really want to engage in open source, sharing your code, because it's no longer a trade secret when you share, right? And you also, in this community, it's all about sharing. And if you really want to be, this benevolent donor, and you want to engage in open source and giving and taking from the community, you don't want to be seen as a hypocrite, right? If you're sharing your trade secrets, you don't want to reach out and whipsaw them and say, oh, no, you can't share our trade secrets. We have an NDA here. That's not something you necessarily want to enforce when you're engaging in open source. It's really more about the copyrights, trademarks, and patents going after impermissible licenses or impermissible uses, and not necessarily trade secret. And I'll let McCoy take over for the poll question, number 5. And Shai, if you want to.
Yeah, I got to unmute. Okay, poll question number 5. My company currently has a process, excuse me, for managing open source, or the process of deciding whether to use open source software and complying with the licenses. Yes to both, and it works well. B, yes to both, but it could be better. C, yes, but only to A, deciding whether to use open source. D is yes, but only to B, complying with the licenses. Or E, no to both.
So we have 13% are in great shape, yes to both, and it works well. 39% yes to both, but it could be better. 11% yes, but only to A. 3% yes, but only to B. And then a relatively whopping 34% no to both. No to both with 34%.
Well, I would say, given these numbers, aside from the 13% that are very happy with their program and confident in it, everyone else could benefit from at least, taking a look at your procedures, if not also doing an audit. And again, it's not very invasive necessarily. It's really a matter of asking questions how your company is using open source. And I would suspect, given these answers, that there just might not be a lot of visibility in this area. And an audit can give you that visibility, at least to understand and give you comfort so that there are no surprises. Business people don't like surprises, right? You don't want to have any surprises in this area, and just understand it and get comfortable with it.
Okay, let's talk a little bit about the process of managing open source, which was the subject of the poll question. So let's go next slide. One of the basic things that I often tell people is, if you're writing software, you need advice on open source. The reason for that is something that was talked about at the beginning of this, which is open source is pervasive. It's everywhere. There are a number of different websites that you can go to where there are thousands and thousands of open source packages available, free download to anybody who wants to access them. GitHub is probably the most prominent, but there's another place called SourceForge, and there are many, many other repositories around the world where one can go to get these sorts of things. And let me tell you, you may not be aware of them, but your software programmers are, and they very, very well may be looking to these repositories to see, well, I need to write a module that does X, Y, Z. I wonder if there's something on GitHub that does that and will make my job easier. Maybe I can just download it and use that, or use it as a model. So most people, or most clients, or most companies who say, yeah, we're writing software, but we're not using open source at all, are probably wrong about that. They may not know what's actually going on. The second thing to be aware of is license compliant needs to be part of your build process. And for those of you who are not familiar with software engineering or the way that software programs are made, the build process is the process of creating software and assembling it together into an overall product. As part of the process of writing and assembling it, very often you will find that people who are doing the writing of the software are getting parts from open source repositories or some other open source. Having a compliance program tends to be a fairly important thing, so that if people are deciding to use open source in your product, you become aware of it. Earlier rather than later is better. The nightmare scenario for a legal department or an open source compliance department is, yeah, we're launching on Monday and we just identified 7 or 8 open source software packages in our software product. What do we need to do? Now, sometimes you can scramble and fix that problem. Sometimes you wind up saying, well, if you're going to do that, we may actually have to reveal the source code for that software product, and that wasn't part of the plan. So if you identify the fact that people are deciding to or wanting to use open source in the product early in the process of creating it, you can mitigate these sort of issues and problems early before they become a problem for your launch date. The nice thing about this is, I started doing open source legal and compliance advice over 20 years ago, and there really wasn't a whole lot of materials or information available for people to sort of figure out how to do this. There are now. One excellent resource that I would suggest you take a look at if you're looking to build this into your processes is a thing called OpenChain. OpenChain is an initiative by participants in the software industry to come up with a standardized scheme for how to go about the process, identifying open source software in your software, addressing the license terms effectively, and making sure that the software that you ship out the door is fully compliant with any open source obligations that you have. It's free to join. It's now an ISO standard, so it's something that the software industry is trying to get everybody to standardize to. And they have a lot of helpful materials from which you can try to start assembling together a compliance process without having to start from scratch. Another thing that's very frequently part of a compliance process in most corporations of any size these days are the use of tools. So these are software packages that one licenses, usually for a fee, that you can run your own software through, and it will identify for you if you are making use of any open source software in the construction of your own software. So that's one way of using an automated process in order to say, hey, we're making use of open source software. We need to be aware of the software license that's attached to that software and what we have to do. Mm-hmm. There are a variety of different vendors for this, and I'm not going to plug any one particular one of them. I've worked with most all of them, and you kind of have to look into this on your own and see which one works best in your software build environment. But there's also been an initiative in an organization called the Linux Foundation to come up with a sort of an integrated compliance tooling suite that most of the industry would then be using to make sure that everybody understands in the same way how to go about doing these sorts of scan and analyzing the results. So take a look at that too, although this one is fairly new and really hasn't got a lot of usable content out at the moment. Okay, let's go to the next one.
Well, McCoy, one other point. You and I have talked about this before. I think it's something, especially people who are not familiar with open source, should understand. It's not like going to confession. There's no shame in using open source. No one's going to get fired because, oh, you used open source, right? No, it's none of that, right? It's all about getting visibility on what you're using. And most companies, big companies especially, they just say, go forward and make the best product that you can. And let's triage the open source and see what the obligations are. is some of them are onerous. Well, you got more work to do. We have to do some, we have to fix something, right? And you make these fixes, right? And usually, and again, so McCoy and I have worked together. We've tag teamed on these things. I'm more on the intellectual property protection side, and I'm very familiar with protecting IP when you're using open source. And McCoy has these many years of experiences of just seeing everything and understanding the triage. And it's usually, and McCoy, you can talk about this a little bit more, when you're doing an audit, you're talking to the engineers. And in fact, we can even give instructions usually. Here, guys, go to your engineers and ask the following question. Let's get a list and figure out where are they getting this stuff. So you can talk a little bit about on that, but it's not that invasive, and it's something that's really worth doing. And again, you're not going to uncover wrongdoing, right? Evidence of crimes. This is really just getting visibility and comfort, so there's no surprises, right?
Yeah. These licenses are ones that most people either have a sense that they're using them, or even if they don't, understand, if you have a discussion with them about it, understand that, well, you know, I'm going to have to do certain things that I otherwise wouldn't do, but in the end, it's not a big problem for us. We'll comply with the license. We'll disclose the source if we're required to do it, etc. And the other thing that you often see, and again, this is both with big and small companies, is you're starting to see a fairly consistent movement toward a thing called an SBOM, SBOM, software bill of materials. So very often companies are now doing this thing where they auto-generate, or they by hand generate a data set that identifies all the pieces of software that they are using, where they originate from, either internally or externally, and what the license terms are that are associated with each of those packages. And you know, the industry is working on ways to automate that process and to automate the analysis of those things. SBOMs have also become very important in security. So you've seen, actually, the White House has put out a couple of papers that said, you know, this is something that the industry needs to move to, not necessarily for license compliance, but for security compliance. So understanding what an SBOM is, and perhaps moving towards a internal program that generates those sort of things, is something you may want to think about.
A great task also for larger companies that have legal ops managers and officers, right? Yeah. Kind of like a Sarbanes-Oxley compliance, and you know, having this very easy thing to check off, so that again, you know, some things you don't worry about. Give the officers, give management comfort that there are no, you know, issues lurking.
Right. Most larger companies are going to develop a thing called an OSPO, O-S-P-O, which means Open Source Program Office. And that's going to be, usually there's at least one person that's their job, but in many of the bigger companies will have an entire team. And their job is not only to understand what's going into the software and understand the license obligations that go with it, but also to engage with open source authors out in the community to further develop the software that they are creating, to make sure it works well with their own products, or make sure that critical or vital open source software that is a dependency for their own software products continues to be maintained and has enough funding so that it survives. So for the bigger companies that are on the call here, thinking about putting together an OSPO, if you don't already have one, is something that you may want to get to think about. Okay, so the next thing is, mixing open source can sometimes be complicated and occasionally is impossible. So some of these licenses are internally contradictory. So for example, if you have two different pieces of software that are under copyleft terms, you may not be able to combine those two pieces of software together and comply with the licenses, because one license will say you must comply with me, the other license says you must comply with me. Well, you may not be able to comply with both licenses at the same time for a combined piece of software. These are the most tricky issues that we open source lawyers deal with is when you get into situations like that. So just be aware that in certain circumstances, people will want to put two pieces of software together in a way that they really can't, and you have to come up with some sort of workaround. It's kind of a combination of an engineering and a legal workaround to make sure that you're not creating these sort of conflicts between licenses.
Here's a question for you, McCoy. It's from the chat box. How would an open source strategy differ between a small and big tech companies? Really?
I think for the most part, they tend to be just questions of scale and maybe personnel. So, you know, I do a lot of work with smaller companies who really don't have an internal organization to do this stuff, mostly because they don't need it. You know, they have a relatively clean build, software build that's almost exclusively their own stuff, and they may have a piece or two that comes from open source. So they'll, you know, occasionally need some consultation or help periodically, once a year or twice a year or something like that. For the bigger companies, you know, they tend to have a dedicated internal team that in some cases working, you know, they will have meetings once a week to say, okay, here's a new software product that we're developing. Here's what we know about the open source that we're going to use in it. Let's think through the strategy on this to make sure that we're using it correctly and we're using the best software that we can. So it's just, in many cases, just a question of scale. If you're the bigger company, you probably need more internal resources. If you're a smaller company, you may just want to contract out those services.
Right. Lots of great questions, but we'll get to that at the Q&A.
All right. Now, this is where it gets really complicated. So oftentimes, I have discussions with people, or you will see larger companies have an internal discussion where they say, listen, I need to see an actual diagram of your software stack and to understand from somebody technical how all of these pieces in your software stack work so that I can give you good advice about the way that you may be using open source software in that software stack and whether that's something that creates some concerns or creates some compliance steps that we need to follow. And this is because, unfortunately, and for those of you who remember this from law school or have been worked with this, figuring out the legal mechanics of copyright as it relates to software is a little bit complex. Unfortunately, you know, there was this Google versus Oracle case that came out of the Supreme Court within the past 2 years that many people hoped would sort of resolve a lot of these sorts of questions, and it didn't really. So you still get to the point where, okay, we have to look at how does one analyze derivative works under copyright law for software? What actually is eligible for copyright protection in the realm of software? Because there is some stuff that shouldn't be protected by copyright, as well as the question of fair use, which wound up being the question in the Google versus Oracle case. All of these are not exactly clear in US law. They're a little clear outside of the US, but in the US, they're not all that clear. So oftentimes you're having to have this discussion where you say, well, based on my research or my review of the current state of copyright law and software in the United States, and based on the description that you give me of the way in which various pieces of software interacts with one another, here is my best assessment of what that means in terms of how we must comply with the licenses. You wind up having to do a little bit of software engineering plus legal engineering at the same time when you get into some of these very complex questions. So it helps to have oftentimes a lawyer who is somewhat conversant in the technology, or a technologist who's somewhat conversant in the law, or both of those working together to sort of puzzle through these questions when they get somewhat complicated. All right, let's go to the next one. Okay, so this is a little bit more Dave's, but I will comment on it first. which is, as Dave said, there's plenty of room for patenting, even if you're playing in the open source space. But you do need to be aware that there are patent licenses embedded in many of these open source licenses, and possibly implied licenses from the use of these licenses to patents. So the closer your use of open source software is to important parts of your patent portfolio, the more your patent department is probably going to need to be or want to be involved in decision making on your use of open source code. That doesn't mean that your patent department has to be involved in all of these decisions. And it doesn't mean that the patent department is going to tell you, you must never use open source software. That's just not the reality here. But when you start playing around with open source software that's really directed to key parts of the technology in your patent portfolio, you probably want to have a consultation with either somebody in your patent department or somebody external who is very familiar with what's in your patent portfolio.
Yeah, I think a good point. Those are all great points. And I think this emphasizes the point that, again, this is a system for the informed, right? And it'd be great if you can to have someone internally who can at least flag these issues. Open source, patents, look out. I don't like those buzzwords, right? And engage with it, right? I worked with a very large company that was, IP wasn't necessarily central to their revenue. And they had a person internally that, the business people want to engage in open source. They want to just get this product done. They want no friction. And this person who was handling open source was just very agreeable. Okay, yeah, go ahead. They didn't look very deep. And they ended up getting very deep in obligations that they didn't expect, right? And so it doesn't always mean, and it shouldn't mean, that you're telling these business people, I'm sorry, I have to throw some friction in here. I have to make it difficult for you because you're getting into something where there is this egregious license, right? That doesn't usually happen. They just need to be aware of what they're getting into. And there might be, again, one of these, fringe open source licenses that they may or may not need. There might be other alternatives. And the obligations are just so high that no, let's look at another way to do it. And engineers are great at doing that, right? But being aware, being able to monitor it and at least spotting these issues. And everybody on this call can be expert enough to spot these issues and put the flag up, and call McCoy, call whoever you have in your lifeline, whether it's your patent department or if you're a smaller company of outside resources. Look into it, ask the questions, and just avoid these often bad surprises. Poll question number 6, Shai.
I'll read it off. So poll question number 6, as a result of today's presentation, A, I feel I have a better handle on what open source is and what it means for my company. B, I feel I may want to adjust some of the things my company is currently doing with open source. C, I feel I need to go back to my company and figure out what they're doing with open source. Or D, I feel worried.
And for everybody here, I'm seeing that a lot of people here need to revisit their open source program. So reach out to us. In fact, you can reach out as in smaller groups or as individuals, and McCoy and I would be happy to talk to you together or separately, and just to give you an idea where to take off. I mean, this is not a black art. And it shouldn't be, right? We can give you the tools to go back, take a look, and we'll give I'll speak for myself, free consultations to get you started, right? And there's a lot you can do on your own to triage your system, spot these issues, become that expert, and figure out what you need to do.
And I'm glad to see that the I feel worried answer is getting very little uptake. So it sounds to me like most of you have a general handle on what this is and what it means for you, and you're not freaking out, which was not the intention here.
Right. But for those 8 people, give us a call today. We'll give you that free call and calm you down. You need to sleep tonight. Okay.
All right. So just to read off the results, 42% feel like they have a better handle on what on open source. 19% may want to adjust some of the things the company is currently doing. 34% feel like they need to go back and figure out what's happening with open source, and luckily only 5% feel worried about open source as a result of today's presentation. All right, so we are going to go to Q&A. So first of all, thank you, McCoy and Dave. That was fantastic. We have a ton of great questions. Okay, so we have a ton of questions for Q&A. So I'm going to get into it, and I plan on going through them all because they're great questions. So if your question hasn't been answered yet, just stick around. Okay, so first one, for software that is used internally, like that is not distributed externally in any way, what are the risks from using open source? And when scanning software for compliance, can one safely set aside non-distributed code and tools and not check them?
Yeah, that's a good question. The two risks that I typically talk to people about with internal only code. The first is oftentimes internal only code, somebody doesn't understand it. It's supposed to be internal only, and they decide to pick it up and plug it into something that's going out the door. So just make sure that if it is supposed to only be internal only, it truly is, and nobody mistakes that for product code that they can make use of. The second one is there are a few licenses out there that are designed to trigger open source obligations if you're running software as a service. So if the meaning of internal only code is, well, I'm running my SaaS system internally, the only way people are getting access to that code is, through a portal that I run over the internet. I'm not distributing the code to them. They're just accessing it through my website. There are a couple of licenses that actually say, if you do that, you now have to give the source code over to the people who are accessing your SaaS service. So be aware of that as a potential concern if you're running SaaS.
What's your perspective on licensing agreement provisions in light of the log4j vulnerability and other open source vulnerabilities?
Yeah, so this is an internal debate that you have in the security community, of which I'm not technically competent enough to have an opinion one way or the other. But it boils down to this. It's better to have closed source code for security questions, because by giving the source code away, you are helping people who want to violate security understand how your software works and put together a hack. The open source people say, actually, no, by obscuring the code, by not making the source code available, you have fewer resources to mitigate the problem when it comes up. If you have the source code that is open, you have thousands or millions of developers who can come in and help fix it. I don't know whether which one of those positions is the most correct. I think we all know that closed source code has had vulnerabilities to security problems, as has open source code. So I don't think there's enough data to say one is more vulnerable than the other. There are certainly resources out there. I know the Linux Foundation has a initiative specifically designed to mitigate vulnerabilities in open source code when they pop up and fix them. So it's not like there's no way to address security problems if they're in open source code.
Got it. What about, if you're a seller who uses open source components in your products, how do you recommend handling an indemnity or, for third-party infringement or security?
Yeah, we didn't talk about this, but almost all the open source licenses come with no liability at all. They disclaim to the fullest extent possible in whatever jurisdiction you're in, any liability, indemnity, et cetera, for the code. So if you're going to use open source code, you're on your own in terms of any liability that it creates for you. Do you want to give indemnities for open source code that you give? Well, that's a business decision that you have to make, given that you've got no liability protection coming in. If you're giving out liability protection for that, you're essentially insuring somebody else's code against problems. Whether you want to do that or not really depends on what you're charging for it and what you think the risks of it are.
What do you believe are the key measures a development team needs to have if they want to have a hybrid / open core model? Like, i.e., if they want to offer some features via a licensed model and then a basic model, via open source.
So this is something, open core is, for those of you who are not familiar with the terminology, open core is a business model that a lot of people are now adopting, where you have part of your product is open source and part of it is not. So you're making money off the not open source part of it, and you're leveraging the open source part of it to sort of make use of an existing code base that is robust or familiar to your customers, or which you can get access to without charging a fee. The key problem, or the key thing that you need to think about with that model, is making sure that when you're putting your product together, you're doing everything you need to do to keep the not free or not open source part of it not open source. So you're not causing problems with that code because of the way that the software interacts that has an open source license.
Okay,
a lot of companies do this these days. That's a big business model that people are adopting.
Got it. What are some, best practices or compliance processes for software distributed in containers that have, OSS licenses implicated? You're loving these questions, hard-hitting questions. Right?
Yeah.
These are excellent questions. The compliance with containers is a whole kettle of fish. If you are interested in this topic, there's a guy, Dirk Hondel, HohnDel, who has done a lot of writing and presenting on this particular topic. It is complicated. And for those of you who don't know what containers are, those are complicated themselves. But essentially what it is a way of packaging together a bunch of different software and delivering it to a customer, potentially in a way in which you deliver a small piece of software to your customer executes it, and then it pulls a bunch of software from a bunch of different places and builds that software for them. The issue with containers is you're now relying upon somebody else's compliance for the product that you're delivering to your own customer. So you probably need to be fairly confident that they're doing things correctly, or you're going to create a problem for yourself and for your customers.
And you definitely want the right waivers. You want to make sure that you cover your liability, but it's like herding cats.
Yeah.
Containers
are very convenient things. That's why a lot of software companies use it, but you can't just ignore what it is the people that you're relying upon to make your product are doing.
Another question, and we have a bunch more. So once you've published your open source code or your code open source, is there any realistic way to block use of that code for certain practices, like, mass surveillance or military applications for certain countries? You could add that to the, in the license text, but enforcement would be very, difficult or tricky. Is there any realistic ways to limit open source code for being used?
Yeah, so this is another question. It's a very good question. It's one that's been a subject matter of debate for the past 4 or 5 years. Technically, for a license to be open source, you cannot impose those sort of restrictions on top of it. So you can't say this is open source, but you can't use it to Russia. You can't use it. because you're a bad country, or you can't use it for surveillance. Technically, that makes it no longer open source because the recipient is not free to do whatever they want, including bad things. Now, depending on the license, you can't, like I said, the permissive licenses allow you to convert it to your own license. So conceivably, you could put it out under a license that says, don't do this bad thing with it. Other licenses, like the copyleft licenses, don't allow you to do that. Now, the philosophical debate that's been going on the past couple of years is why shouldn't we allow people to call something open source and prevent people from doing terrible or bad things? And you get two sides of that debate. Some people, it's sort of like the debate about the First Amendment in the United States. Some people are absolutists and say you ought to be able to say whatever you want. That's freedom of speech or freedom of software. And other people say, well, there are some sorts of speech that are so terrible, we really ought to prevent people from exercising it, which is the people who say, yeah, that's the same thing with software. We ought to be able to say there are certain things that are so bad that you shouldn't be able to do it even with open source code.
And on the other side of that, by the way, there's you don't want to confuse that with anti-competitive behavior. I mean, people, and that's where the debate usually goes, right? Unless you have a mechanism for discerning between those, then it's not fair to exclude it, right? Probably subject of another really good, more philosophical presentation. Yeah.
Maybe that'll be the next one we do. All right, next question. In SaaS sales contracts, I noticed some providers will state that their software includes OSS components and others don't bother. Is there a general consensus that if you don't have any copy theft licenses, but only use Apache/MIT, that there's no need to flag this for clients in the SaaS agreement?
Yeah, you guys have some very good questions. Everybody seems to know what's going on. So, for example, the Apache license does require that a copy of the license be provided, as well as copyright notices. So in order to be fully compliant with Apache, you would need to make people aware that there's a license associated with it. Now, it may very well be buried someplace, like in the README or whatever that comes with the binaries, versus in the SaaS agreement itself. I think as a general practice, it's better to have in the agreement some notice that says there is open source software in this. And if you want to find out about that open source software, go to the README or go to the addenda to, or the exhibit to the software license. I think that's probably better customer practice to make them know, what they're getting, but it may not necessarily be required.
Got it. Next question, and we had a bunch of, I'm kind of grouping questions together. People are interested about what are the consequences of breaching these licenses. So I'm going to read the three questions and we'll go from there. Interested to learn more about the damages models for these types of issues in the event of non-compliance with a open source license. And then another one, let's say you don't comply with a copyleft provision. Are there any trends of enforcement, as a copyright violation versus a license term or a contract? And then, if you use a copyleft license and you don't release the code, can you take it offline and rework it without the open source? Do you have to pay damages? Do you have to be subject to specific performance? A lot of questions about enforcement.
Well, there's a lot of loaded questions in there too about, what is it, if it goes underlying, what is a derivative work, right? And how much can you undo?
Let's talk about enforcement, because that's very topical. If you haven't seen, there is a potentially groundbreaking case going on right now in Southern California. It's called Software Freedom Conservancy versus Vizio, V-I-Z-I-O. It's a company that makes displays and TVs and stuff. And that's, I think, the first test case where somebody is trying to enforce compliance with an open source license, not under copyright law, but under contract law. It's also the first case, I believe, where somebody who is not the copyright holder, so didn't actually write the code, but is a recipient of code, has said, I am, because the open source licenses are between the copyrighted author of the code and the person who receives code from them. In this case, the receiver of the code is suing the intermediate distributor of the code under a third-party beneficiary theory of a contract. That's a case that is the first time anybody's ever tried that theory, and it's now in the physio is trying to get it removed to federal court and saying this is just a copyright case, it's not a contract case. That's one to watch, because depending on how that turns out, you may have new theories of liability for these sorts of licenses and new potential plaintiffs for these sorts of situations. You know, it has historically been the copyright holder has to go in and enforce the non-compliance with the license. On damages, it's interesting because most of the enforcement actions that have been done, and they're primarily been done in Germany and the United States, most of the people who are filing suit aren't really asking for a lot of damages. They're asking for compliance. So they're saying, pay me, you know, some nominal amount of money, maybe for my attorney's fees, but what I really want you to do is fix the problems. But that doesn't necessarily have to be the case. And there's a couple of cases in Germany where somebody asked for some actual, you know, money payments beyond fixing the problem. United States, that really hasn't been happening, but you never know. I don't know. It's an interesting legal theoretical question about what actually are the damages for somebody who's been giving their software away for free. But that's never really been tested out in any way that I know of.
Very interesting. Cool. So I have a few more questions, and this is a last call for questions. And then, you know, we have time, so we'll do some virtual networking when this is wrapped up. So I have some specific questions. And basically, this question is about what happens if a developer releases a program in violation of, I guess, the open source, you know, regime that they did it under. So the question is it possible for a panelist to opine on when a developer releases a program under GPL v3 within the code distributed without reference to its website, but on its website under terms and conditions, it seeks to restrict the copyright by stating the first user is free and then every extra user a fee applies? Like, is such a thing enforceable?
The GPL says you can't do that.
Good luck.
So,
Right.
so you potentially got a conflict between the terms and conditions that the code is being distributed under and the GPL, unless there's some sort of carve out in your SaaS agreement that says, you know, if you make more than one copy, you got to pay me. But that doesn't apply to the open source code that's in here, you know, and so you can get around that. But so it depends a little bit on what the actual agreement says. But technically, you cannot say to somebody, I'm going to give you something under GPL, but if you make copies of it and sell it, or make copies of it and distribute it, you got to pay me. That GPL says you can't do that.
Got it. Next question. Are there any copyleft licenses that could trigger source code release or commercialization releases based on integration with no use of the code within an open source SaaS platform into your commercial SaaS authoring? You know, and he says, I believe even AGPL would only cover it if open source code were actually used in the offering.
Yeah, so this is another topical and complicated question. AGPL, so the Affero GPL is the one that I talked about, where it says, if you make this software available over a network to another party, you got to provide them with the source code. But that only applies to the AGPL code and doesn't necessarily apply to other code that you may give access to that's not governed by that license. However, there are a number of companies that have been experimenting with even more comprehensive licenses. There was one called the SSPL, Server Side Public License, that was quite controversial a couple of years ago, that was trying to say, if you make money in any way off of a software as a service in which this code is used, you have to pay me, or you can't use this. And then there was a huge debate about whether that was or was not open source. And I think most people said that's not really open source. So people are experimenting with this model. And there are a couple of licenses out there that try to do, I think, what you're describing people attempting to do. MariaDB, I don't know if MariaDB did it. I think it was MongoDB that was the one that was using the SSPL. So the database companies have been the ones who, basically this is a beef between several different database companies and Amazon Web Services. They've said, Amazon Web Services is using our database as part of their back end, and they're not paying us anything for it because they're using the free license, and we got to stop that. And they changed the license, and there's this big brouhaha over whether that's open source or not, and whether that's what Amazon is doing is appropriate or not. And go to ZDNet or CNET or one of those sites, and you can read all of the debate about this. You really have to look at the license.
Got it. What a fascinating world of open source we live in.
I got to say, there's always some hot topic every couple of months that everybody gets exercised about, and there's a lot of debate about. And if you're playing in this space, it's good to monitor what's going on, because these things are they're interesting.
Yeah, very. So last question, and then we'll do some virtual networking, and it's a general one. What can you tell me about using openinventionnetwork.com as a patent pool? Is that even familiar? What can you tell us about that?
Yeah. So I've known the guy who runs OIN for almost 20 years. Here's what OIN does in a nutshell. You can join it for free. And what it does is it says all the people who join the OIN commit that they will not assert their patents against a defined set of software that is the open source infrastructure that they all rely on. So it's sort of a patent peace agreement amongst companies that say to one another, listen, there's some software out there that is important and needs to survive, and we need to commit to one another that we're not going to go around and start suing it for patent infringement. They have, I don't know, hundreds, if not thousands of companies that have signed up to that. I think most of the big tech companies now participate in that, because they say, what we don't want to have is wars amongst us over each other over patents on stuff that we all rely upon. It's just destructive to the overall open source infrastructure that we all need. Other than that, I can put whoever asked that question, I can put you in touch with the people who can give you their pitch. They got a pitch deck, and they can tell you all about the advantages, disadvantages. They also recently have said they're going to try and do some stuff around patents that external patent risks to open source. So stuff where it's not a big company who wants to join OIN, it's a non-practicing entity perhaps that's doing something. So they've got a couple of different initiatives, and if you're interested in that, you should give them a call. They'll be happy to give you their pitch and try and get you to join.
So, all right, two more questions. Is there any newsletters or or periodicals that one can subscribe to stay on top of these developments?
I tend to rely mostly on the kind of general trade press places. So ZDNet, CNET, Slashdot is pretty good. The register, although it's a bit snarky, is good too. Other than that, there is a mailing list that is part of a legal network that I participate in for people who have to work within open source. That if anybody is interested in joining that mailing list, drop me a note and I can talk to you about getting you nominated for that. They also run a conference every year where lots of technical and legal people get together and talk about, interesting issues in open source compliance or open source licensing. The nice thing about it, it's in Europe every year. It's supposed to be in Sweden in next spring. So if you're interested in traveling and going to that, it's an excellent, it's the best conference in the world, I think, for these sorts of questions.
All right, cool. So this is like the final question, and it's Dave. I'm not sure if you're paying attention to the chat box. There's something. Do you see it? All right. Do you want to summarize what the question is and then explain? Because it looks like Elliot is requesting that you respond. But I'll give McCoy a little break.
It's not really clear. I would invite Elliot to reach out separately on that question. We're kind of running out of time, and it's kind of a loaded one. So I would just leave it at that. Yeah.
Okay. All right. Well, there you have it. So first of all, thanks again, Dave and McCoy, for a fantastic presentation.